Welcome to Sakshi TV special immigration talk show with lawyer Srinivas Kaveti. Please note that Sakshi TV now has 5 immigration shows every week. On Mondays with Somi Reddy Garu, on Tuesdays with Mr. Kaveti, on Wednesdays with Prashanti Reddy in English, on Thursdays with Chand Paratnini, and on Fridays with Banu Rindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usaidsaakshi.com or call us at 866-725-7441. Before we begin the show, please note that the information provided on this show is not for legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any legal advice, please contact the attorney directly. Mr. Kaveti needs no introduction, but if you need consultation, you can definitely log on to their firm. They have a wealth of free information and online tools in the hands of immigrant community. So without any further delay, let us welcome Mr. Kaveti Garu onto our show. Kaveti Garu, welcome back, Andy. I hope you're doing well.
Yeah, thank you, Shivani, to have me.
Yes. So, Kaveti Garu, today we are going to be talking a little on the different side. I don't think so. We hardly spoke about this specific topic. So, we are going to be talking about divorce. So, before we get into what actually divorce is, can you first explain us the institution of marriage and what is it, so that we can go topic by topic into the main headline?
Yeah, actually, when you see, divorce or marriage, the institution of marriage, this is actually, it was not there. If you see, when during the time of when we were barbaric society, people were nomads, in the jungles, women and men, they were going everywhere. So it was not civilized. When the civilization started, this institution of marriage came. It came in BC in Mesopotamia, they said in Greeks and Catholics, Hebrews, and they said, we should get married because to control the society and to legalize to have children. And that's where the institution of marriage started. I mean, if you see, even in Bible, there was nowhere mentioned Adam and Eve. There were two individuals in that garden. But, when you see that even in Hindu Dharma Shastras, there's some Shastras they mentioned about marriage, but when you see the history before Christ, it was in Mesopotamia, and I think 200 BC or something, 250 or something. So that's where the marriage institution started. Why they did is to control the society, to have a organized, to have couples, to have a monogamous, to have couples and to have children. So that's where it started. It's part of sociology to control the society. That's what marriage institution started.
Yes. So can you tell us when and where did this institution of marriage exactly start, Mr. Kaveti?
I mean, when you do the research on institution of marriage, it is said that it started in Europe, and that's where it started, actually, the marriage institution during time Mesopotamian, civilization. And slowly it went into the, Greek and Italy, and it went to Israel and other parts of the world. That's what it is mentioned. If you do the research on family law, the reason I am familiar with it is because in my Masters of Law, I took family law. So we did a research on institutional marriage and divorces. And that's the reason, I gathered that from that time. And we have done some research also on that topic. Because a lot of times we get calls from India and other parts of the world that people get divorced in America, whether this divorce is recognized in other parts of the world. So that's where it comes, actually, That's the reason we explain them, because marriage is performed in Hindu law, marriage is performed in the Christian law, Islamic law, and special marriage law, and marriage is performed in America. So what is the legal recognition of it? We come with a marriage certificate. Civil marriages are there, Islamic marriages, Christian marriages, getting married in a church, and going and getting the marriage registered or recognized. So that's where it starts, everything. That's the reason we had to do some research on advising clients on divorce and where is the right place for getting marriage registered and recognized. That's where it is.
Yes. Now let's get into the main topic, Mr. Kaveti. It's about the divorces. So, what are some types of divorces? I think the most common ones are the fault and no fault divorces. So, can you in detail explain about the types?
Well, in good old days, if you see especially Hindu Marriage Act, and if you want to get divorced in India, there are certain grounds. They used to have 9 to 12 grounds. They said you have to show some faults with the party, with either husband or wife. That was called fault divorce. That means you have to find some fault. For example, how do you say that? Maybe the husband and wife, they're doing some cruelty, either physical or mental. Or sometimes you have to show that the husband or wife or infidelity. That means they're going out with somebody else. Or sometimes the husband and wife got married. Or sometimes the husband and wife, they went into jail, or they have some mental issues, or they are physically unfit to, you know, lead a conjugal life. Or sometimes you've gone to jail also, you're a criminal, felon. So there is, and sometimes in some laws they said if you change your religion also, under the Hindu law, that could be a ground to divorce. But that was fault divorce. But what has happened after the human rights and everything, they said you can't keep somebody against their wish. So then slowly came into no fault divorce. That was the first time passed in America. No fault bill by Ronald Reagan signed that in California. He said you can also divorce a person without filing any fault. So that's called, no fault. That means there is irretrievable differences. I can't be with you, and this is not going to work. So I don't have to show fault. I can still go ahead and file a divorce. So that's called no fault divorce, and that has come into Indian system also, and many European countries, US, UK, Australia, New Zealand, all these Anglo-Saxon countries have no fault divorce now. So that means one of the party doesn't have to show, that you're incompatible. You're not compatible physically. You're not compatible, on a marital basis. So you can say, okay, I want to get out of the marriage and marry somebody or even date somebody, do anything. So that's called a no fault divorce. And it started in America during the time of Ronald Reagan. And now most of the countries have adopted. And recently, even Supreme Court of India said you can also file no fault divorce in Supreme Court also.
Yes. So, Mr. Kaveti, let's get on to what exactly is a contested divorce. I think I'm getting it. Is it contested?
Well, contested means, one party says yes and another party say no. And because with the, family law, once you have a divorce, there you have a children sometimes who gets the children, and sometimes they have a property, they buy a property together during the marriage, and how that has to be distributed, who will keep the children, and who is the breadwinner, and how will the spouse will get some spousal support, or even child support, or even sometimes alimony. Sometimes, women, they are full-time, homemaker, and they lose their professionalism. They might have a degree, but they have to go back to school to get a job, things like that. That's where the alimony is granted. So, all these things are called contested. That means both the parties are not agreeing, and then they go to the court. So most of the times, the court system, the family law says, instead of going and fighting, go for a mediation, settle it down. So contested means both the parties are not agreeing to the terms. Uncontested means both are agreeing outside the court and say, okay, let's have a peaceful divorce. Let's not pay to the courts. Let's not pay to the attorneys. Let's agree and settle amicably without court's intervention. Of course, sometimes, when they agree, have a stipulation of settlement, they go back and the judge signs that. That's called, uncontested.
Yes,
Contested means you're fighting. Uncontested means you're not fighting.
of course. I think you kind of did explain a little about what both are. I want to get into the laws, Srinivas Garu. I think that is the main topic. So, what are some laws? Are laws in India and USA completely different from each other, especially on the topic of divorces? So, firstly, I think it'd be better if you kind of explain the Indian laws and then you can go to the US one.
Well, if you see, our country in India, because we have Christian law, we have Hindu law, we have Muslim law. So the law pertaining, I mean, there's a special marriage act. And if two interracial religions get married, if somebody is a Christian or a Muslim or a Hindu or a Muslim, that's a special marriage act applies, and the Indian Divorce Act applies. But in America, the 50 states have 50 different laws, and every state governs by the family law. So, there are some states that have Spanish influence, some states have English influence, some states have French influence. So the law pertaining to 50 states have their own 50 laws, and it's a state law. So, for example, if you take New York, and they say that, under the family law of New York, you go into the court and make an application either to the family court or to the Supreme Court. So every state has its own laws pertaining to America. If you see international law again, there are some Hague Conventions, and the United Nations came and said, let's make some countries uniform. I mean, laws are similar. But if you see Muslim law, if you say if Middle East, or if you come to a country like India or Bangladesh or Pakistan, they have personal laws because the law said, let us not get into the personal laws. Like Hindu law is different. If you're divorcing and if you're having maintenance or child support, everything will be decided by the Hindu law. And if you're a Muslim, under the Muslim law. And if you're a Christian, there's a Christian law. If it is interracial, then the Special Marriage Act applies and Indian Divorce Act applies. But the beauty is once any court decides about the divorce in the world, it's recognized. So all the countries, they recognize personal laws. So that's the difference between the Indian system and American system.
Yes. Let's get on to the longevity, Kaveti Garu. How long does the contested and the uncontested law go for? And are there any specification in these kind of laws?
First of all, because when you go to litigation, it is very difficult to say what is the time frame. But a typical an uncontested divorce means, sometimes in India they call it as consent divorce, that you're consenting to it. So that typically takes 3 to 4 months in countries like America. But in India, it takes forever because of the clogging of cases in the courts. It takes about maybe 1 to 2 years sometimes. And, uncontested divorce, if both the parties are coming together, they have to have their own lawyers. Most of the issues are settled in terms of their property, who keeps the children, what the husband would pay the wife in terms of maintenance, child support, if there's any alimony, exchange of gifts, or even dowry, all of that. That's a little easy, but because you're not going for a trial, and that is faster and it's cheaper. And somebody, if they're going for contested divorce, it might take forever because in America we have seen clients even spending $250,000 for the attorney fees, and it went to up till 4 years, 5 years sometimes. So the time frame we cannot say if it is contested. And many times people ask us how much it costs. We cannot. Basic, anybody would charge $7,000 for an uncontested. Contested, there is no limit. One of our clients, she spent $250,000 just for a divorce. $250,000 means 2.5 crores. She spent just for a lawyer's fees. So it's not that easy to tell that how much it costs. And the time frame, sometimes people are filing motions, they're fighting back and forth. And sometimes people have properties in America, properties in India, and multiple countries. They have shares in India, shares in America. Sometimes they have companies in here, overseas, internationally. They have some properties overseas in terms of mobile, immobile. And sometimes they have properties before marriage and after marriage. Sometimes they also get gifts. separate property. Sometimes they win lottery. There's so many aspects of it, very complex. If it gets contested, that becomes complicated. And sometimes people also get educated, during the marriage, and their salary goes up. So, and sometimes one of the spouses, they leave the job, take care of the children. But after the, divorce or before the divorce, they become unemployed. So they want to go back to school, and who has to pay for it? So it's very complex, contested. So they're expensive and time consuming.
Yes. Mr. Kaveti Garu, I think this is a very common question that a lot of NRIs would have. Is the divorce that is granted in America, is that considered in India too, or do they have to go through two different divorces, one in America and one in India?
No. This question we get a lot of times, and people from India also call us, and clients from all over the United States, they call us. But there is a jurisprudential aspect of it, and there's also international law. One is one must understand if there are jurisdiction issues. For example, if somebody comes to America on an H-1B, and even though they got married in India under the Hindu law, they come and they started living in America more than 6 months to 1 year. Let's say they are living in husband and wife live in Florida, and they have a child in America, Florida, and they've been in America for 2, 3 years, but now they want to get divorced. The question comes that most of the time they say, "Oh, we got married in India, and somewhere in Tirupati, can we get divorced in America?" There are three things in jurisdiction. One is called, if you're living in Florida, the Florida courts would have jurisdiction. It's called personal jurisdiction. You're living, as you both the persons, plaintiff and defendant, are living in Florida, so the courts in Florida will have jurisdiction. Number two, you're living in that particular territory. Let's say you're living in, Tampa, Florida. The Tampa, Florida, you're living husband and wife. The Tampa, Florida courts will have jurisdiction. That's called territorial jurisdiction. And you're living in personally both husband and wife in Tampa, so you have a personal jurisdiction. And the third thing is, okay, you came to America, you lived, you have children, you bought a house, you got a business, or you got a job, and you're living, your children are going to school here. So one is called territorial personal jurisdiction, and you fought, you got separated, you want to get divorced in Florida and Tampa. So it's called subject matter jurisdiction. That means because the fighting is happening in Tampa, Florida. So you go to the Tampa, Florida courts. Most of the times, the advocates in India, because of they don't understand these things, they say, "Oh, because you got married in India, you can come and divorce in India." Yes, the Hindu law says that if your marriage is performed in India, you have an option to go back. But again, the proper venue, this is called the law of venue. What is the proper venue? You're living in America, you're living in Tampa, you're living in Florida. So the Florida state law applies to you because you have a property, you have a child here, and your divorce is here. So you apply in the courts of Tampa, Florida. And when both the parties, husband and wife, appear before the court and they file an answer or they fight, and the judges says, "Okay, now you're getting divorced, you get divorced. Who gets the children, who gets the house, what is the spousal support, what is the child support, what is the alimony, who keeps the children, when the children can visit the father or when the children can visit mother." All these issues are settled. Let's say they have a property in America, property in India, or they even got some, lottery or some pension. There's so many aspects. When there is an equitable distribution of property, either movable or immovable, in America, it's called real property or a personal property. When these are all decided, the judge signed the judgment in America. Of course, the judgment is final because there is a doctrine behind it. It's called, once the court decides it in American courts, the other courts cannot question. Why? There is a doctrine called res judicata. Means what? Once the issues are settled by an American court, by a Tampa court, the other courts cannot entertain it. That's called a res judicata. That means you cannot litigate on the same issue to another court. And there is a second doctrine is called collateral estoppel. which is a doctrine of equitable law. Many lawyers in America, many lawyers in India or other parts of the world, they say, oh, you have to come back and take another divorce in India or take another divorce. You have to be recognized. Oh, this divorce, which is passed by the Tampa, Florida court, is not recognized. That is wrong because under the Hague Convention, under the doctrine of collateral estoppel, under the doctrine of res judicata, it is a recognized judgment. Once one court gives, you can't go to another court and do a forum shopping. That's called forum shopping. You can't, go from one court to another court, give trouble to the other party. That is against the law. So unfortunately, we're getting a lot of calls from US itself and from India and other parts of the world. Sometimes we get calls from UK because I am also I'm admitted solicitor in UK. We get calls saying that, sir, we've taken a divorce in UK. Do we have to go to Andhra and get another divorce or to India another divorce? The answer is no. Based on these two laws, one is called res judicata, second is called collateral estoppel, and the international law, which says the law of US Constitution says that it's called law of comity. That means full faith and credit. Once the law is passed or judgment is done by the courts of America, it is recognized under the Foreign Judgments Act in India or even CPC, Civil Procedure Courts in UK, other parts of the world do recognize foreign judgment. Even Supreme Court of India said it is recognized in India. Only you can challenge that when one of the party did not appear, when the other party became an ex party. That's a word used in England and in India. And in America, it's called default judgment. That means, let us say the wife files a case and husband did not appear. And the wife took the judgment. And sometimes the wife files a case and husband is served a notice, but husband refuses to appear before the judge. And the judge, after due trial, he passes a judgment after trial or after considering all the issues, he passes a judgment. That is a valid judgment. If you want to challenge the judgment, you have to go to the same court. Sometimes, these lawyers, advocates from India, because they don't understand the international law, American law, and they give wrong advice saying, oh, you have to go and challenge that in Indian courts. No, you cannot challenge that. The challenge can be done by the same court where you obtained the divorce decree. So this is a misnomer. So I wanted to clarify this. The reason I have more clarity of law because of my legal education in US, legal education in England, and legal education in Australia and America, and also in PhD of law. I understand the law better in 4 or 5 contexts than a regular person who went to school in one country.
Yes. I think Srinivas Garu, with this, we have to end today's session. There's something coming up. So I think we can continue more because we do have a lot of other questions. I think next week we will definitely continue on this topic. The viewers, I hope you guys will tune in again next week. Thank you so much, Srinivas Garu, for tuning in. Thank you so much for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.